Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. We're here for oral argument in case number 1 CACV 16-0781, Joseph M. Arpaio versus Hines GS Properties, Inc. Counsel, just a quick reminder that we are recording this, so if you'd please identify yourselves and who you represent at the beginning of your arguments. Each of you will have 20 minutes. Counsel for appellant, if you'll watch the clock and make sure you reserve as much time as you would like for rebuttal. And also, we have read the briefs. We've discussed the case in conference, so we're familiar with the basic facts of the case. With that, counsel, you may proceed.
Your Honor, my name is Jeff Sertikowski. I'm here representing Sheriff Joe Arpaio, the appellant in this matter. Your Honor, this matter in trial court was dismissed via a motion for summary judgment, and the basis for that dismissal was the expert testimony that was provided by the appellant was excluded. We feel that was excluded improperly, and based on 702, I will just basically state the basic standard is an expert testimony, as long as it is reliable and relevant, is acceptable and should have been accepted in this case. To begin with the reliable standard, that actually should not even be at issue here, as the defendant had never, and the appellee never even argued against the reliability of the expert witness's testimony. In this case, Your Honor, what this is about is there is a sidewalk that has a V shape to it with a drain in the center of it.
Called a cross slope.
A cross slope, thank you. Yes,
okay.
Thank you. Mr. Arpaio, Sheriff Arpaio at the time, was walking across that walkway, which is a major thoroughfare. As he was walking through that crossway, his head was up, and he fell when his foot hit the area around the drain. We have Mr. Arpaio retained an expert who is an expert whose qualifications, again, were not challenged in any way. In fact, the defendants hired an expert themselves, and in the trial court, it was even stated that their expert clearly said, Ms. Sharon Bonesteel, Mr. Arpaio's expert, is best in the state at this stuff. So they didn't even challenge the measurements and what she did. What she determined, and why it is relevant, is if that cross slope is out of code. Now, this is where some confusion did come in the trial court. Arizona does not have directly written code on walkways or sidewalks in that nature. What the Arizona Code points to is it says to be in code for the city of Phoenix, it must meet the ADA standards. Therefore, what Ms. Bonesteel, through her experience and her knowledge, provided the court was that the ADA standards stated that the slopes had to be to a certain degree. These slopes greatly exceeded that. For that reason, this walkway itself is in violation of the codes. That was one of the proximate causes of the fall that was concluded. Now, again,
Well, how could she conclude that was the proximate cause without knowing the mechanism of the fall?
well, first of all, Your Honor, there was a video that was experienced, that was viewed. This was raised in oral argument at the motion for summary judgment.
There's a video of the fall?
Yes. That was raised in motion for summary judgment and objected to by defendants, which I believe was an error for that not to be viewed by the judge, since the defendants actually provided that video to us. So by viewing that video, that's how it was determined by this expert exactly which drain it was that his foot came down near and how the fall occurred. At the same time...
You don't have the video.
No, Your Honor.
Okay, so...
Okay.
At the same time, it was in the trial court's records. At the same time, the measurements were taken of the entire area. There were other aspects that were included, including cracks and settling of that cross slope. So just the area as a whole was included in her report and her determination. One of the aspects under the, again, using the Daubert standard, her measurements were therefore relevant. Now, if you ask if the conclusion that she made was relevant itself, not necessarily, but this should not, summary judgment was still not appropriate, even if the trial court judge decided to exclude her conclusions. What it did was raise that question of fact that was necessary. And in the light most favorable to the non-moving party, we had presented that this crossway itself was not flat, at the very least, created a situation where somebody could fall, and we know that because somebody did fall. And a trier of fact, reasonable minds can determine, is it because of the way this sidewalk is built, or the way it had been maintained, or in our opinion, not properly maintained, or was it simply a fault? That is a question for the trier of fact. Another statement that was, another argument that was made by the defense, yes. Okay. Another aspect to this is if it's an open and obvious hazard. Now, open and obvious hazards do not allow for summary judgment just just by themselves. An open and obvious hazard, as it was argued in the trial court under Johnson v. Tucson Estate, Inc., what that states is there can be a situation where there are distractions, and a distraction can cause somebody who has knowledge of the area, like Mr. Arpaio did, who possibly could normally see that, to forget that that open and obvious dangerous condition exists. This was a major thoroughfare. It is surrounded by multiple restaurants, a light rail, and it is heavily filled with people at the time that this event occurred. That is the kind of distraction, again, that creates that question of fact for the jury to determine if Mr. Arpaio was not staring straight down at this open and obvious hazard. It doesn't matter how many times he passed. According to that case, that's the kind of distraction that creates a question of fact.
Let's go back to your point, which I'm not following probably as well as you've explained it, but what exactly constitutes, in the expert's opinion, what constitutes the the hazardous and dangerous condition? Is it the cracks and the settling, or is it the slope?
It's all of it, Your Honor. It's full inclusive. You have actually, and then there's a separate.
Did the experts say that?
Yes.
In her affidavit?
Yes. In the affidavit, in the report, there was actually an additional one where the sidewalk itself is actually moving away from the wall. So the expansion, and I can't remember the technical term she used.
But even if the expert says this, if Mr. Arpaio says in his deposition, "I tripped over the drain," how can that jive, or how can that fit together with the expert's opinion? It's directly contrary to the expert's opinion that there was cracks or settling. When the expert agreed, I thought that it wasn't uneven where the drain was.
Okay, and that is where the pictures actually would come into play, and those were presented to the judge. What you have to use is the actual physical image to see what we're talking about. The cross slope itself, it's not slanted in one direction. This comes down to a V. As it comes down to the V, the drain is right in the base in the middle of that V. So as Mr. Arpaio was stepping through, it's the cracks, the cross slope itself, and how the drain sits. The drain can be flush at the bottom of this, but it's at the bottom of what I would say a canyon, in essence, where he's coming down into all of this all in one configuration. And that was the point. It's not one just, and that's what the expert stated. She wasn't looking at just one particular thing, not just the crack, not just where this drain was. The drain being flush at the bottom of this still created the hazard because of the dip and the settling that had occurred, which was far beyond the scale of what is supposed to be allowed. Does that answer your question? Or?
Yes, in part, but I'm still struggling with her opinion, with the expert's opinion on the slope. It seems like, so she's clearly tied it to, I thought, that it was accessibility, that those are the standards for those people under the ADA that need that level of slope.
It's not that it's the...
So it seems like you're suggesting that we need to apply that same level to the public in general.
In this instance, when there is a walkway like that, the point is Phoenix has not provided independent guidelines as to what that slope should be. They say it must meet ADA standards. So I believe that question has already been answered by stating that these slopes should all match what an ADA standard would state, and therefore, yes, Your Honor, it's not an ADA question. It is simply, what does Phoenix require? And this particular walkway is not within the Phoenix requirements. And then just briefly, the final aspect is Mr. Arpaio was a business invitee. So there is that using Tribe v. Shell Oil and Nicoletti v. Westcor, the affirmative duty was also presented. I'll reserve the remainder of my time.
Okay.
Thank you.
Thank you.
Thank you, Your Honors. My name is Tony Vitagliano, and I represent Appellees Hines. There's a couple of misstatements counsel has made. I want to touch on those first, and then most of the other misrepresentations I'll address during my presentation. First, the surveillance video. The surveillance video is not in the record. Counsel misspoke. It was provided in discovery, but neither party submitted it in the summary judgment motion, nor in the response, nor in the reply. Therefore, it is incompetent to view for purposes of this court or the lower court because nobody submitted it. And the reason they didn't is because it was fuzzy, it's unclear, and you can't really tell. And if you go to Arpaio's appendix, Exhibit 17, page 14, lines 10 through 18, you'll hear the discussion at the court why it's not in the record, and since it's not in the record, it's not proper evidence for summary judgment. Likewise, the discussion about distraction, Sheriff Arpaio, this also, I believe.
Well, the court didn't have it and didn't consider it in ruling on the motion.
Correct. It wasn't part of the record. Nobody submitted it, including plaintiffs in response, because it didn't show anything that anyone really could point to. It was fuzzy, it was unclear, it looks like it's on the side of the building, etc. So let me get into the main issues and then hit some of his other misrepresentations of the record. First, the court should affirm it because the lower court did exactly as they should under 702A and under Rule 56. Under 702A, the judge is the gatekeeper and makes a preliminary assessment on whether proposed expert testimony is relevant and reliable. If it's not, it's inadmissible. Likewise, under Arizona law, a condition that people may be expected to handle without precautions as a matter of law is not an unreasonable, dangerous condition, and that where reasonable persons could not differ in determining that there's no unreasonable, dangerous condition, the court properly takes that issue and declares summary judgment.
The argument that I heard this morning seems to suggest that the city of Phoenix in their code requires buildings to be constructed consistent with the Americans with Disabilities Act, and there's a question of whether that was done here, and so there's a question of whether or not it meets the building code.
Yes, Your Honor.
Okay, which is,
I can
it
address.
seems much more fluid, much more concrete than at least in the briefing or what I otherwise saw in the preliminary or supplemental reports.
Yes, Your Honor. Whether the cross slope, and the cross slope is over here, over there, you'll see from the pictures, and all the cases show, you can tell from the pictures, that it comes down the drain, but the slope that she's measuring, that she says is there may be breakage, those are all away from the area where he tripped, and you'll see that in her opinion as well. whether the cross-slope of the walkway complied with the ADA's handicapped accessibility provisions is irrelevant to whether it created an unreasonable injury to Arpaio, a person not physically handicapped. Not only has the property never been cited for any such alleged noncompliance, nor has any person previously been injured from any such alleged noncompliance, including Arpaio during his 12 to 13 years using that area. But the ADA provisions that Arpaio's alleged were not complied with, they're titled the accessibility for the physically handicapped. And they do not apply to Arpaio, who's not physically handicapped, and thus they're irrelevant to his allegations of negligence. And I'm going to address that.
Yeah.
Contrary to his reply, in light of his attempt to Arpaio's attempt to rely on Bonesteel's opinion, Arpaio's lack of physical handicap is relevant. In his appellate brief, page 2, for the first time, he alleges a per se violation as grounds for their claim. Not only have Arpaio's abandoned this argument by not raising it before the trial court or in their opening brief before this court, they also can't meet its requirements. As set forth in Hatch Development LLC v. Solomon, 240 Arizona 171, appellate 2016, at
Counsel,
page...
I have a question, which is what I think we've been trying to get at. So has the city of Phoenix adopted the ADA standards for the construction of sidewalks?
The city of Phoenix has building codes that refer to the guidelines and also talk about times when they don't have to necessarily be met. But as Hatch describes, failure to comply with it, even if that were the case, and we're saying, one, that's totally speculative. Two, her claim that it had to do with that is totally speculative. As this court has noted, there's no testimony in the record about that. She creates that on her own. And I think our brief is clear, and I certainly can go through those points where case and case again says sheer speculation on the part of the expert can't create a fact issue.
Let's stick to this issue. I think you can tell the court's concerned about this issue. If I'm going to go out and build a building with a patio out or a sidewalk or whatever it is, why in the world would I do anything different than build it to ADA code? Because I'm assuming that I have to accommodate every single person, whether they're disabled or not, or whether they need accessibility or not. So why would this building be any different?
This building was built in, I believe, 1998. These various provisions were talked about at that time, but the code that plaintiffs refers to is dated, I believe, 2010 or something. So these old.
There's no obligation to update your building at any point to become.
Nor is there any nor has there been any violation notice, nor has anyone else overfallen.
I understand that.
So at the time they complied with whatever they had to comply with. Otherwise, they would have been noticed that they were not in compliance. But they did, and they've never been noticed since then. So the idea, we don't even know if her measurements are correct. The court properly found that they were not helpful, they were irrelevant, they were inadmissible. So they may well be in compliance. We're not here to argue whether they're in compliance or not, because we believe in this case, and certainly according to Hatch, that requires to comply with the law or regulation enacted for public safety to establish a breach of duty. One, the conduct must be the proximate cause of the injury. As this court already said, he tripped over the drain. He does not talk about anything else. He wasn't distracted. If you look at the record, he was looking straight ahead. He wasn't on his phone. He wasn't distracted. Both he and his deputies with him, trained investigators. This is the sheriff. We all know Sheriff Arpaio. We all know his department. He's with a group of deputies. Nobody takes a picture. Nobody says there's anything wrong with this area or this drain. He's one of hundreds of people walking over this area, and no one else has fallen. I mean, people trip all the time. The cases are clear. Our brief is clear. Just because someone trips on the property doesn't mean it's an unreasonably dangerous condition. Even if there were a defect, just because there's a defect doesn't mean there's an unreasonably.
So even if the area, and looking at the picture, didn't comply with the ADA in terms of the slope by, whatever differences there are, even if that's the case, it's still your argument that he tripped and fell and that slope isn't responsible, or the owners of the building aren't responsible for that trip and fall.
Well, you're right on both counts, Your Honor. There's nothing in the record that indicates any slope had anything to do with the fall, and the owners of the property have no negligence with the fall. In fact, Bone Steel's opinion indicates there's no disrepair where Arpaio tripped, and that, quote, the drain cover itself is flush with the walking surface in compliance with code, close quote. That's in Bone Steel's March 16th, 2014 preliminary report, Hines Appendix, page 49, paragraphs 6 and 8. Thus, not only is the record devoid of any evidence that the alleged ADA noncompliance was the proximate cause of Arpaio's trip, but also Arpaio, who is not physically handicapped, is not one of the class of persons that the ADA's physically handicapped accessibility provisions meant to protect. So, regardless, even assuming arguendo the truth of any alleged noncompliance allegations, which we do not, Arpaio's had abandoned that argument by never raising a per se violation below. There's no breach to Arpaio because he's not of the class of persons protected, and it never affects proximate cause. And as the court has noted, the plaintiff himself testifies, there's nothing else that caused the fall. I tripped. They told me it was a drain. He was looking. He was not distracted. The record's clear. He was not on his phone. He was looking straight ahead. There was no distraction. He simply misstepped. We all do that, and some people are more litigious than others, and some, when they misstep, they'll take ownership for it, and some may not. But the record's clear. There is nothing other than the attempt to fabricate the record to support any claims of negligence on the part of the Hines. Contrary to Arpaio's reply, this is not about all pedestrians and all public walkways. It's about a particular plaintiff and the particular spot where he tripped. Arpaio has no evidence of any fact showing Hines breached their duty of care or anything caused his fall from their conduct. No facts presented into evidence shows that Hines did anything that was negligent. Neither Arpaio, as we said, none of his deputies, nobody noticed, took any pictures, and they're all trained investigators. No broken slabs.
Whether they are, the only information is the trip and fall, and then the architect's analysis that she did 1 year later. So there's no indication of whether the walkway was wet.
There was,
or the other back on
right,
February 28th of 2013.
The building engineers did an investigation as soon as they heard of Arpaio's fall and found nothing out of the ordinary, nothing defect, nothing that would cause a fall. And as I said, hundreds of people walked over there, and including Sheriff Arpaio in 12, 13 years, and he's never fallen. And while counsel says, well, you could walk over it once and not fall, you could fall the next time, well, that's true. But since 1998, we don't have complaints of people falling over these, then it's by law, by Arizona law, it's not an unreasonably dangerous condition, and therefore the court was correct in ruling that Judge Arpaio should have been able to handle that without any other precautions or what have you, and people can slip. Yes, Your Honor.
Just going back to the question, just so that I can be clear, it's your position that you don't know whether the Phoenix code for the building of sidewalks adopts the ADA standard or not? You don't know the answer to that?
No, Your Honor. The Phoenix Building Code talks about compliance with the ADA code. That, of course, develops later, and it develops over time. And it also has, if you read the parts that are in the file and the parts referred to in our brief, it also talks about times when, well, if that can't be complied with, well, that should, it doesn't make it a fait accompli. It makes it sound like, well, other things should be considered. So whether or not the statute, clearly the statute was different back in 1989 or 1998. We know that because the version they look at is 2010, I believe. But even though they said, well, it was being talked about back then, well, yeah, it was, and there's no question. And as Judge Brown articulately noted, if I'm building a building, especially, we all know Renaissance 2. We all know the size, the capacity. We all know where it is, how it is. If you're building that building, you're going to make sure you comply with code. So I agree with Your Honor. There's no doubt they complied with code at the time. Moreover, there's no doubt that they've complied with them since because they've never been received any statement or ruling or ticket, whatever you want to call it. They've never been cited as being non-compliant. It's clear.
There's nothing in the record that we have.
Correct.
Okay.
Correct. And I can tell you there's nothing that I'm aware of, doing the case. And as again, it's sheer speculation what Bonesteel's opinion is, and therefore the court correctly did not allow it for numerous reasons. As we said, first it's sheer speculation. He says that it was the drain. He doesn't even know exactly. He tripped. It must have been the drain. The cross slope doesn't apply to him. Those ADA provisions, they have to do with people with handicap, and he is not one, and therefore under Hatch, that cannot be used as a breach against him because he's not the class of person meant to be protected. Again, that's Hatch versus Solomon, 240 Arizona, 171, App 2016 at 177, paragraph 21. That's because that's the first time plaintiffs talked about a per se violation. Likewise, Bonesteel, she says in her own report that she talks about other areas she found these things that plaintiffs are talking about, not the area where he fell. Well, those other areas are irrelevant to this case. The only thing relevant to this case is he says he tripped over the drain, and what does she say about the drain? She says it's, quote, the drain cover itself is flush with the walking surface in compliance with code. Third, whether it created an unreasonable risk of injury to a person without a physical handicap, that's in the personal knowledge of anyone because we're all those people. So we can look at it and we could say, well, gee, that looks like something that would be hard to negotiate, or we wouldn't. So Bonesteel's opinion doesn't aid and is not helpful and is therefore inappropriate under 702 because that information is within the knowledge of an individual jury just as well as it's in Bonesteel's. Fourth, by stating failure to comply with the ADA handicap, its approximate cause, she's also instructing the jury how to decide and therefore invading their purview. So there's time and time again reasons why her record shouldn't be closed. Let me just touch quickly.
Aren't there, opportunities where the court could have struck in portions of the report without striking it all?
Well, and let me address that quickly. Plaintiff says that's what they should have done. Well, that's exactly what they did because as set forth in our briefs and as I just said today, The entirety of Bonesteel's opinions were speculative, irrelevant, inadmissible, and unhelpful under 702A. It's all speculative. Therefore, all of it is non-compliant, not just the bit where she says proximate cause, but the entire opinion. Arpaio also alleged the trial court should have let in Bonesteel's inadmissible opinion and allowed experts to battle it out. As held in Tiger Construction 29 F. 3rd 137 at 142, that would have been reversible error. There the court held, quote, it was an abuse of discretion for the trial court to admit expert testimony based on assumptions which are speculative and not supported by the record. This error resulted from the trial judge's belief that the question of whether an expert's opinion had an adequate basis in fact should be handled by opposing counsel through cross-examination and in jury argument. The court may not abdicate its responsibility to ensure that only properly admitted evidence is considered by the jury. Expert opinion, evidence based on assumptions not supported by the record should be excluded. Excluding the expert's opinion, there remains no evidence establishing a causal connection. That's cited in our brief, and that's 29 F. 3rd 137 at 142, Tiger Construction. That's a Fourth Circuit case. Finally, even assuming the court erred in not admitting Bonesteel's opinion, that would be harmless error because admitting Bonesteel's opinions would not have changed the result. Summary judgment would still have been warranted, as Bonesteel's opinion would still have been irrelevant and inadmissible, speculative and irrelevant, and thus incapable of defeating summary judgment.
Counsel, your time's up.
Thank you, Your Honor. If there's no other questions.
Thank you. Do Your Honors have any questions for me before we begin?
Nope.
Okay, I'll just address that last point first. The speculative and not supported by the record, as Your Honors have been presented, Ms. Bonesteel, this is not an expert coming into a courtroom who had never seen the site, who had never seen anything. These are her measurements that were taken. This is her scientific foundation that is supported. These are her observations of the area, and it's her expertise that allows her to do this. As we presented, Ms. Bonesteel is that person you go to when not only is a building being constructed, but when other changes are made to those buildings. Now, as a reminder, that area has a lot of changes with the restaurants, which is something Ms. Bonesteel talked about, how restaurants will change. The light rail was put in recently. Therefore, those codes, those standards do apply to that walkway, and they do apply here. What was presented to the trial court were statements both in scientific fact and basis, and a presentation of the arguments that there is a walkway with a cross slope that is a dangerous condition that caused a fall. It was approximate cause of that fall, with the drain sitting at the bottom of it, and it caused the damages. And that should therefore have not been dismissed via summary judgment. Those are questions of fact that a jury should determine if that is in fact true or not.
So the jury should get the fact that Mr. Arpaio is at the time, a healthy adult who was walking on an area, tripped and fell, and then the jury gets to figure out whether it was his walking or whether the slope that had been there during his previous times in that area were responsible for the fall?
Yes, sure. It goes to the weight, not the admissibility. There is a sidewalk that is designed in a certain way. Is that what caused, we have argued that's what caused his trip and his fall and the damages. And the defense will present that no, that's not what caused it. He's a healthy man. He just tripped over his own 2 feet. We've seen that argument, but that it's in its own right creates that question of fact. And any plaintiff in that situation deserves the right to have a trier of fact decide that and have the jury hear those questions of fact.
Okay.
Is there anything further?
No, I don't think so.
Thank you.
Counsel, thank you both for your your arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court will stand adjourned.